Srivastava, which specifically says in PG, you will not relax marks unless there are exceptional reasons, and you will relax it to a limited extent of 5 or 10 percentile.
Who are these persons?
First two petitions. There, one is Youth for Equality Manoj, who have filed petitions before on maintaining standards of education, maintaining and adherence with reference to admissions into educational institutions, etc. The second is the Society of Private Clinical Establishments.
We'll file a detailed affidavit, my lord.
Now, I'll just take 1 minute. That's all. I'll let them file their affidavit. I have no problem. I just want to give your lordship some basic facts. There were 2,30,000 candidates who sat for NEET-PG. The numbers who were found eligible were 1,28,116. So 1,28,116. The total number of candidates, the total number of seats which are available is 80,000.
2 lakh applied.
2 lakh applied. Appeared for the PG exam. Those who are found eligible is 1,28,116. The number of seats available are 80,291. Now the regulation, the PG regulation which applies specifically says, this is regulation 9, specifically says in the second proviso, and that is the only one that they can claim benefit of, that 50th percentile will be the minimum marks, 45th for general category, 40th for SC, ST, OBC. And the percentile shall be determined on the basis of highest marks secured. Now,
that's why we should not.
so the proviso says, proviso is the only one that applies. Proviso says, when sufficient number of candidates in the respective categories fail to secure minimum marks as prescribed in NEET test held for any academic year for admission to PG courses, the central government, in consultation with Medical Council, now NMC, may at its discretion lower the minimum marks required. So if at all, this is the clause that they can claim benefit of. So the test is that you should not have enough candidates available. 80,000 seats, 1,23,000 who are coming within that 50th or 45th or 40th percent. So let them answer that.
The answer is
I'm saying,
What we said.
so no, I'm saying now, no, there's a second aspect. You cannot go, you cannot go all the way down to minus 40, which means if they didn't sit for the exam, they were in a better position.
Well, that is the reason why we asked
Yes,
them to file affidavit.
yes.
Why all this?
No, I know.
For telling that
grateful, my lord.
necessary. Next.
61 also
When I-
plus the same. act.
58 and 60.
And it's just one indulgence, if they can also specify in the affidavit as to up till now, whatever seats have been filled after third count.
Our conscience has to be satisfied
Yes.
that there's no devious reason. That's all that we
And
see.
it will only make them eligible to take part in the counseling.
No,
It will
Manoj,
not do
I-
admission.
Have a look.
Manoj, I want to be fair. I don't think any of us are alleging that it's being devious at all. We are not saying that. We are saying you have to have some basic.
Gopal, what's happening
Yes.
is every day we are seeing till last moment. On the one hand, we have this competing value to protect that seats should not go waste.
Correct.
At the same time, there is a pressure that enough candidates are not coming. Please reduce the cutoff. The argument then will be that if you reduce the cutoff, you are bringing down the standards. And the counter argument is that if you don't put up the cutoff, seats are going waste. So somebody has to take that balance.
Yes,
When to
but so-
reduce, when not to reduce.
No, but to be fair, I don't think the aim is to fill every single seat right to the down.
To take, it's
Yeah.
for the-
Even-
unless their action is something
Yes.
drastically wrong. But it
Yes.
appears to us
Reducing
that
it-
it is.
But there's a difference between the undergraduate seats and PG graduate.
While you are
That's-
We will file it.
under what
Preeti-
circumstances you have done.
In fact, Preeti Srivastava says higher standards for higher levels,
Post-graduation.
not lesser.
All
Leading specialists.
As time passes by, we keep reviewing those judgments.
Very well.
Grateful, my lord.
Grateful.
Will not physical appearance may be taken in the matter.
They might say that you don't
Lord, in 60, I have filed an affidavit.
Ah, yes.
Lord, before going into that,
Lord, can I see, my Lord, okay, can I show the affidavit, my Lord? Few paragraphs.
1 minute, my brother.
I'm sorry, my apologies. Yes, it would be affidavit dated 18th January 26.
Where's the copy?
My Lord, please come to para 3 at page 2. My Lord Justice Narasimha, my Lord. It is the constitutional obligation of the state government, more particularly in light of the fact that as per the statistics given by the Ministry of Environment, Forest and Climate Change, Government of India, as per data, 3,62,000 hectares is under encroachment. In other words, my Lord, in Assam, in other words, a total of 19.92 of forest area is under unauthorized illegal encroachment. It is constitutionally imperative that this unauthorized and illegal occupation, as well as continuing illegal and unauthorized non-forest activities, are immediately removed. That the first step for removal is to issue a notice on the alleged unauthorized occupant to enable him to show the evidence of he being in authorized occupation of the forest land. That the recipient of the notice comes before a committee of forest officials as well as revenue officials and produces the evidence, if any, available with him and which can be, according to the notice, entitle him to stay in the reserved forest area. The actions are taken for removal of encroachment areas only if it is found that there is an illegal and unauthorized encroachment in reserved forest area. If the land of the noticee is found to be within revenue limits outside notified forest area, the details are sent to Revenue Department, and the present drive, which is confined only to evicting the reserved forest area, has nothing to do with what the Revenue Department may or may not do thereafter. That if the noticee is found to be in unauthorized occupation of a reserved forest area, after scrutinizing the documents placed by him, a speaking order is passed. Please mark this, my Lord. A speaking order is passed and served upon him, giving him 15 days notice to vacate the unauthorized occupation. It is only thereafter that the actions are taken to remove the unauthorized occupants. That so far as controversy concerning the existence of some Gaon Panchayats is concerned, Mr. Ahmadi, my Lord, raised this issue, and it is a correct issue. It is submitted that there can be a Gaon Panchayat in a forest area. This is provided for in section 5 in Assam Panchayat Act. My Lord, I have quoted Assam Panchayat Act. The state government may by notification declare any local area comprising a revenue village or a group of revenue villages or a forest, it should be village but not villager, or tea garden area or hamlets forming part of the revenue village or forest village or tea garden area or other such administrative unit thereof to be a Gaon Panchayat with population of so and so. That the concept of forest village is a unique concept in Assam. A person entitled to stay in the forest village finds his name mentioned in the statutory register called Jamabandi register, maintained by the forest department for the forest village, and the person holds a document for the land and the possession. Additionally, the title holders under the Scheduled Tribes and other traditional forest dwellers, the Recognition of Forest Rights Act, are also legally authorized to occupy the forest land and are not liable for eviction. The rights mentioned above are inheritable but not alienable or transferable. That individuals whose name is mentioned in the register or hold rights under the Forest Rights Act 2006 are not unauthorized occupants. However, there are several unauthorized inhabitants who have encroached upon lands outside Gaon Panchayat limits and in some cases inside Gaon Panchayat limits which fall within the boundaries of reserved forest. That it may be pointed out that a right to reside in reserved forest areas falling within a Gaon Panchayat is inheritable but non-transferable. There would be a separate set of documentary evidence showing authorized occupation within reserved forest areas which are falling under a Gaon Panchayat. Any unauthorized occupant residing inside reserved forest areas, albat falling under a Gaon Panchayat, is liable to be evicted following the same procedure as pointed out above. That in view of what is stated, my Lord, that is now, my Lord, now yesterday we received an affidavit filed by one of the petitioners attributing some statements to the Honorable Chief Minister that we are targeting one particular community, etc. But I have taken instructions, my Lord, it's not community based. My Lord, 500 people of some other community are also removed. And I am making a statement, whoever is unauthorized occupant will be removed.
Yes, Mr.
No, yes, my Lord.
What is this?
I'm sorry.
About this, what is your concern?
I'm,
What your concern? You are saying?
yes, I'll tell your lordships. First of all, this affidavit doesn't reflect the correct position as far as the status of those territories which are in the territorial area of a Gaon Panchayat are concerned. The moment an area is is notified by the governor to be a Gaon Panchayat and part of a Gaon Panchayat under Article 243 of the Constitution, read with Section 5 and other sections of the Assam Panchayat Act, which was framed pursuant to that, that territory is vested in the Gaon Panchayat, and that territory is directly linked to the population of that territory. This thing that there might be a Gaon Panchayat inside a reserved forest is a complete misnomer. The first thing which has to be done is to identify and demarcate the Gaon Panchayats which have been notified. Now, I'll show your lordships in a moment. Please come first, notes, to the Constitution for a moment. Just see Article 243, lords. What is being done here is just mixing up the whole thing. And we argued this before. We'll have to see the orders in the separate matters. But in the first matter, this is argued before the High Court. High Court notes that it is our case that we are within Gaon Panchayats which are notified. But he says, no, nevertheless, you have to be evicted. So please see Article 243, Lords, Part 9. This came in, Lords, pursuant to the 73rd Amendment Act. In this part, unless the context otherwise requires, please see, Gram Sabha means a body consisting of persons registered in the electoral rolls related to a village comprised with 243B. 243B, your lordships have?
Yes.
Gram Sabha means a body consisting of persons registered in the electoral rolls relating to a village comprised within the area of a panchayat at the village level. Then see E. Panchayat area means the territorial area of a panchayat. Now, population, F. Population means the population as ascertained at the last preceding census of which the relevant figures have been published. Village means the village specified by the governor by public notification to be a village for the purposes of this part and includes a group of villages so specified. Then Gram Sabha, Article 243A, a Gram Sabha may exercise such powers and perform such functions at the village level as the legislature of the state may by law provide. Now please come to 243C, capital C, composition of panchayats. Subject to the...
I understand his concern. I'm taking care of your concern. Any person in Gaon Sabha, if he is not an illegal encroacher, as I have pointed out, it is heritable but not transferable.
No, I'm not on forest villages.
If it is a Gram Sabha, heritable properties would be protected. Unless you are an encroacher even in Gram Sabha.
I'm sorry. I'm sorry. I'm sorry, this
Yes.
is wrong. But what the
And that's
affidavit is
order
dealing with,
passed.
affidavit
It's subject
is
matter of
talking.
Last time we thought you are all for agreeable for all.
No,
that's how
and
Lord,
that
I
is
also
also
understand.
No, I had at the outset pointed out your... I had at the outset pointed out your lordship. No, Lord, I'm sorry. When I opened the arguments, I had pointed out your lordships and I showed your lordships the notifications issued by the governor of Assam as recently as 2023 and 2024, notifying these villages, revenue villages. The notices which are issued to us for eviction are in... one sec, please, Mr. Solicitor.
You are not concerned.
You are concerned. You are concerned with revenue villages. The notices issued to us are for demolition of our houses with house numbers in the revenue villages. Therefore, there has to first be a demarcation of all the Gaon Panchayats, and only then, only those who are not in the Gaon...
revenue villages, Malad, in this.
I'm sorry, Malad.
I've seen your affidavit.
There's no point going on like this.
This is confined to the forest.
I want to show your lordships, they are not forests. Just to say something that 200 years ago there was a notification of a forest, therefore it's a reserved forest.
All right,
So the point is, if it is a Gaon Panchayat notified by the governor, the territorial area of the Gaon Panchayat is linked to the population of that area. So I just want to show that. Kindly allow me. Yes.
Okay.
Now please see 243 capital C, composition of panchayats. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of panchayats, provided that, now please note this, provided that the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall, as far as practicable, be the same throughout the state. So there's a
What? These are constitutional projects.
How
Where
is
the
this
debate
relevant?
about
so
this?
pursuant to this, now your lordship has seen that the Gaon Panchayat consists of the territorial area of the panchayat. Pursuant to this, the Assam Panchayats Act is enacted, which I placed before your lordship notes, and your lordship would just kindly come back to that for a moment. Please see the Assam Panchayats Act. What is the page of that? No, your lordships had seen it last time. It's we had.
Seen it last time.
Yeah, I just want to show your
Why are you
lordships.
repeating that?
I'm sorry.
Why are you repeating that? We have seen
I'm
that.
repeating that because I want to show. I want.
About this, what is your concern, Mr. Singh? Last
My
time
concern is.
we asked them not only an oral statement, but we wanted it to be put on an affidavit.
So what they have
put
put
it-
on affidavit does not, what they have put on affidavit does not meet that. Because the moment it is a Gaon Panchayat notified, it is outside of the forest, revenue forest, of the reserve forest. There cannot be a Gaon Panchayat, once the territory is notified with a population in it, it cannot be within a reserve forest. This is only,
But just see
it's
this
only a
here.
bare statement made.
Look at
So
this here.
please see the notification just for a moment now.
Just
Please,
come to this, come to this.
just see the provisions of the act first, Lord.
That on receipt of the notice comes before the forest so and so, that the actions are taken for removal of the encroachment only if it is found that it is an illegal and unauthorized encroachment in the reserved forest. Unauthorized encroachment, once they have agreed that it is possible to have Gram Panchayat even within the precincts of the forest.
It is not
Then
so.
when you are possessing
I'm saying
the
it is.
encroachment-
I'm saying that is wrong. It is not so. Once it's a Gram Panchayat, it is not within the reserved forest. Your lordship is
But
there.
irrespective of whether
I'm
it's
sorry.
reserved or-
Look, I'm sorry. I need to make this point because I told it has perhaps slipped your lordship's attention.
Irrespective of.
There are forest villages. They are notified by the governor as forest villages. They are notified by the name forest village. I'll show that to your lordships. The other villages are notified and they are revenue villages. Now to say that a revenue village, now a Gram
Go
Panchayat.
ahead, you complete your
Yes,
argument.
yes.
Then what do you want to show, tell us?
So if your lordship sees the act for a moment, the Assam Panchayat Act.
What do you want to show?
Yeah. Yes.
Show.
Look, where is that Assam Panchayat? There's a compilation which we had given to your lordship. Look.
Yeah, we have to protect genuine.
It says
people.
compilation of judgments, but it has the statutes in it. Yes. Page 271 of this compilation.
It gives us suspicion of what their intentions are. Page
I'll let page 271.
271. 1 minute, huh?
My lord, do your lordship find page 271? The act begins at page 269, 268, Assam Panchayat Act 94. This was pursuant to the 73rd Amendment. The act was enacted.
Which section, what do you want to show?
Yes, please see section 2, subsection 9 at page 271.
Yes, Mr.
Subsection 9 of section 2, definitions. At page 270, village means any local area recorded as a village in the revenue record of the district in which it is situated, and includes any areas which the state government may, by general or special order, declare to be a village for the purposes of this act. Now, look at page 276. Your lordship will see chapter 3 deals with Gaon Sabha. (276), chapter 3, Gaon Sabha. And then in this chapter, your lordship will come to chapter 4 at page 278. Chapter 4, 278, Establishment and Constitution of Gaon Panchayat. Now please see this. The state government may, by notification, declare any local area comprising a revenue village or a group of revenue villages or a forest village or tea garden area or hamlets forming part of revenue village or forest village or tea garden area or other such administrative unit or part thereof to be a Gaon Panchayat, now please see the next, with population of its territory not less than 6,000 and not more than 10,000. So there's a 243 capital C said that it has to be linked to the population, the territory and the population have this intrinsic link. So the notification has to be of a Gaon Panchayat, has to be not less than 6,000 and not more than 10,000. When it's more than 10,000, it goes into a different category. It's now no longer Gaon Panchayat.
We go a finding on all this.
So
We will give an inquiry and then we will give a finding on all this might go against you, Mr. Singh.
I'm
Asking us, you are inviting a judgment on all this.
I'm saying that unless it is first, the Gaon Panchayats are first demarcated and your lordships they lay down which are the areas of the Gaon Panchayat, the next this exercise of verification has to be done thereafter. It's not to say that people have been issued a notice, they should come with proof. You have to, the area of the Panchayat has to be demarcated. Now, if your lordship kindly just sees this.
What else you want to show?
Yes. So, now if your lordship kindly sees further the local area, the proviso, provided that where a group of revenue villages or forest villages or tea garden areas or so and so are declared to be a village, the village shall be known as a revenue village.
Mr. Singh, will you please formulate your point so that it will be easy for us? Because
Yes.
you are merely referring to
My lord.
provisions. So
My
will you formulate your points? What exactly?
The point is
Yes.
that these villages where we are issued notice for demolition of our houses are villages which have been notified as Gaon Panchayats by the governor. As far as I'm concerned, in item 60 and 60.4,
Yes.
with the territorial area which is vested by law in the village panchayat, in the Gaon Panchayat.
So therefore, the notice can't be issued to you.
No, notice can be issued, but first of all, it has to be not as a reserve forest. If it's a Gaon Panchayat and the territory is vested in the Gaon Panchayat, it can't be part of a reserve forest.
All right.
Because this is only.
All right, what next?
Yeah. So and they have said so. They have said so in the High Court in several matters that the Gaon we are not proceeding against anybody in a Gaon Panchayat. So that demarcation has to be done.
They have said here also.
So, but what the confusion then created subsequently is that in the reserve forest there are villages. What I'm saying is that those villages which are notified as Gaon Panchayats under the Act, they stand outside the reserve forest because the territory and the population is vested in the Panchayat. That's the point.
All right. All
Now, and
What
that
further you want?
now, if your lordship sees section 23 of this Act at page 295.
Yes.
Section 23. A Gaon Panchayat shall have powers to acquire, hold and dispose of property, etc. Now, 23(2), subsection 2. All properties within the local limits of the jurisdiction of Gaon Panchayat of the nature hereinafter in this section specified other than property maintained by the central or state government or a local authority or any other Gaon Panchayat shall vest in and belong to the Gaon Panchayat and shall with all other properties of whatsoever.
No doubt about it. Who said that there is any doubt? Who is questioning the correctness of these statutory provisions?
So that's all
Question
I'm on.
inquiry where it falls.
That's all I'm saying.
We'll see,
We'll
take note of your argument.
that the Gaon Panchayat areas have to be demarcated and then they have to carry out this exercise. What they're doing is they're putting an onus on a person who has issued a notice. Let me just show your lordships the notices in my case. In the context of the notification issued by the government. The government issues multiple notifications, the governor. First, he notifies the Gaon Panchayat.
Earlier, it was a situation where they were, we are assuming, when the matter was in the High Court, that straight away coming and then evicting, for which we issued notice.
Yes.
Now they said that there will be an inquiry into the matter.
Yes.
There will be
So
examination
so
of the matter.
all that I'm on.
Giving you a prior notice of eviction, you will be given an opportunity, they will come back and you have.
So
remedies
all
thereafter.
that I'm saying is, and this is all that I'm saying is, and this is pursuant to certain other High Court judgments of the High Court. Your lordship, my learned friend Mr. Goswami is here. He'll point out, your lordship, they have conceded. The AAG has conceded before the High Court that first there will be a joint verification of the Gaon Panchayat limits and the forest limits, and only after the joint verification can notices be issued. They've conceded that the High Court struck down the notices in some matters. But what they're doing is they're saying each of those orders of the High Court will only be treated as orders for those particular petitioners who went to the High Court. So even if there are petitioners from a village or an area or a particular alleged reserve forest, if 10 people go to the High Court, they say we'll only consider that for those 10. We are saying that for the areas which you are proceeding, you must demarcate the area. That's all we are asking
My lord,
for.
to assuage
That
para 3.2, I have said the recipient of the notice comes before a committee of forest officials as well as revenue officials. It's a joint committee.
But first,
Right,
I'm
but
only saying the first step has to be demarcation.
What is your case?
That's the crux. Just one more thing, Lord, I'll say. Your Lordship may just note that I have produced the notifications notifying the Gaon Panchayats and simultaneously the delimitation notifications which are issued by the governor and the election notice. Though the notices issued to us for eviction are on the same house numbers which are in the delimitation notification.
We are not sitting in inquiring into that. That is
Yes.
what exactly we are ensuring that somebody looks into
So
it. Without
that's
that, they
that's
can't
right.
be-
That's right. No,
Why are
and
you
and and
unnecessary?
and
Goswami, tell us.
that the joint verification, we are just saying those that we must be involved in that. It can't be just a committee because there has been a great hostility shown here by the highest constitutional authority of the state.
What is your case?
Can you take up 60.8?
Tell us.
I need to show the order, Doctor. Passed by the
Just
High
tell us, formulate your point.
Come here.
And you-
After him, whenever convenient.
60.8.
My matter is connected to Mr. Goswami.
Come.
No, tell us after.
We have the same region, my lord.
Lordships.
An order, my lord, and I could not oppose the High Court.
Now, in this case, I am representing certain people who are alleged to be staying in the Lutumai Reserve Forest in Nagaon. Now, initially, when notices were issued to us, we went to the High Court. Some of them went to the High Court, assailing that notice. High Court finally passed a direction saying that please have a verification, and then thereafter, if you find that they are actually residing inside the forest, evict them. Pursuant to that first round, the state does do a verification, but a unilateral verification without involving the petitioners, and then issue the second notice of eviction. We go back to the High Court saying that, well, the verification has been done, but it was unilateral in our absence. On that point, the second eviction notice has been quashed. The state has taken a stand. That stand is what I want to point out, Lordship. Kindly come to page 133, para 10.
Which
60.8.
It's a writ petition or
We have come again.
32
so
petition.
is it SLP or 32?
It's a 32.
32.
Yes. 60.8. Please see the
Read
stand.
read that.
Yes. Having considered, in fact, from para 9 onwards, this is important.
कम से कम soft copy है.
60. Lordship does
Read because
which page you said? Which
I am
page?
reading page 132,
133 you said.
starts
Para
from 132.
Justice.
Para 9,
Justice 80.
this is the order dated 28/11/2025, passed in writ petition number 6738 of 2025 by the learned single judge of Guwahati High Court. Now, after hearing both the sides, this is what he said. Para 9, having submitted above, Mr. P.N. Goswami, learned additional advocate general, fairly submits that the authorities are ready to consider the case of the petitioners afresh in view of the fact that the joint verification, which is the basis for rejection of the representation, appears to be only by the authorities in the absence of the petitioners. Accordingly, he submits that the respondents' authorities may be directed to have a joint verification, including the petitioners, to verify the claim of the petitioners. Next paragraph. This is the view of the court. I am of the considered view that the interest of justice would be served if the respondent authorities are directed to consider the case of the petitioners afresh by providing an opportunity to the petitioners to submit their documents in support of the claims with regard to the occupation of the land, and also to have a joint verification including the petitioners, so as to ascertain the actual facts of the claim of occupation
as to whether the petitioners are occupying land within the Lutumai Reserve Forest. Accordingly, the respondents are directed to conduct a joint verification of the entire area. So what we are saying is, Lordship, prior to issuance of the notice,
Joint verification.
it has to be a joint verification, and once that is done, you issue the process will. So that may be factored in, Lordships. I am very grateful. And this is the position considered by the state before the High Court. So that may be
We
important.
take a note of that. The joint verification thing.
Yes, prior to issuance of notice.
You want to go first?
You finish because mine is on a different footing.
May it please your lordship. So I appear in 60.3 and 60.5.
3 and 5. Yes.
May I just invite your lordship's kind attention to the affidavit filed by the respondent.
Yeah, correct.
And if your lordship sees
Which page is that?
the affidavit, I'm not sure whether it's.
At that point.
which I
Affidavit filed
read.
by the state.
Affidavit just I read.
Yes.
That
No, that
affidavit-
we have it.
Yes. If your lordship just sees, my lords.
You just tell us your concern, we will take care of
Yes,
it.
just two aspects. I just want to place that affidavit. And
Yeah,
what I want to request is only this, my lords,
Tell us.
that whatever statements that they have made in the affidavit may be incorporated in your lordship's order
Yes, we're going to
as
do
a
that.
safeguard. That's point number one.
We're going to do that. We're going to do that.
Point number two is, my lords, there's only one concern. And my lords, that I take a stand from the submissions made by both my learned friends in respect of this aspect of the effect of a declaration of a panchayat. Now, the affidavit doesn't say that we will first demarcate and then assess. That's the problem. So therefore, if your lordship sees paragraph 3.2 of the affidavit, that the recipient of the notice, does your lordship have that? That the recipient of the notice comes before a committee of forest officials as well as revenue officials and produces the evidence, if any, available with him, which can, according to the notice, entitle him to stay in the reserved forest area.
In this, what you want?
Now, what happens is, you are first not demarcating what is the reserved forest area, nor are you demarcating the revenue villages. Now, that is the only apprehension. Everything else in the
What
affidavit,
Mr. Singh is saying.
yes, everything else in the affidavit, my lords, appears to be reasonable. So therefore, my lords, my respectful submission is that the
That should somehow
statements
be-
made in the affidavit should be reflected in your lordship's order so that these basic safeguards are maintained. There is one more concern, my lords. Also, my lords, that your lordships passed an order of status quo
In one case we did.
in the first case.
And I think in an
So
SLP
therefore, my lords, going by the spirit of the affidavit, till this adjudication takes place, that status quo should be maintained. That's point number 2. Now, thereafter, my lords, the affidavit, my lord, speaks about a committee.
Yes. What is the third?
The third aspect is, my lords, as regards, my lords, a committee which will adjudicate these rights. Now, my lords, there is a little bit of concern about the constitution of the committee. I leave it to your lordship, my lords, whether your lordships would like
Some senior.
some kind of overseeing,
Some senior.
either by, my lords, someone from the judicial side or, my lords, someone, so that it
They
can.
must well, trust the government. Well, I'm sorry.
Okay, we'll consider that.
Now, my lords,
Then
if I may finish my sentence. There is a reason for that apprehension, my lords. I would not have otherwise made this statement. I make this statement out of responsibility, and there is an apprehension that is expressed.
we'll take it.
And since my learned friend, my lord, spoke about trust of the government, then I am constrained to point out 2 reasons why, my lords, there is an element of mistrust. Just see the affidavit that I have last filed.
Your affidavit?
Yes, my lord. On 4th of February 2026. And I will not read the entirety of it, but I'll just show your lordships a few extracts of that affidavit. Just come to, my lord's, page 10 of that affidavit.
It's filed yesterday. As I said, my lord, attributing some statements to the chief minister that it is communal.
We don't.
Now,
need to get-
if I may just finish, my lord.
There is no end to that.
Yes, my lord. Lord, there is a speaking order passed. There is a high court, my lord, which can be challenged.
Something.
Now
Let
let
us, Mr. Ahmedin.
me at least finish.
Just tell us.
Yes. Now kindly see page 10, my lord. 1 second here. Don't show me mobile phones and chat.
Your document number. It is in 32624. 32624 of 2024. Document number 38982 of 2027. No, February. Document number 38982 of 2026. 38982 of 2026 in SC 32.
You have one more copy, just give it. No?
The office report also yes, 32624. We filed it in there. 32624.
The office report says it is there.
It is there on record. I have a soft copy. iPad, I'll give it to you. Adila. Yes.
Hello, may I hand over my copy? I'll read from the. Sorry, it's Mark.
No issues.
Sorry, it's Mark.
I can hand over my copy also for the both the judges.
One copy will share, that's all.
No, my lord, kindly have.
This will be, you are saying this in the context of your apprehension, right?
Yes,
You don't
apprehension,
want to-
Manoj, please
you don't want
take
to
care
get
of
into
it.
Too much of this.
I have, Manoj, absolutely full faith
Page.
that your lordships will take care of it in whatever manner that your lordship
page?
thinks appropriate. Now just see page 10. Just see page 10.
Emotionally, child, personal. I'm talking to you. Not to
Your lordship may first see the headline.
Yes, we saw that.
Your lordship has seen that. Now, my lords, please see the first sentence, my lords. That this will be targeted only against. No, just for a moment. Let me finish. If I may just point out a few. Just see the headline, my lords.
We saw.
Then your lordship sees the first paragraph.
We saw.
Yeah.
We saw.
Now, my lords, over the page. Please see the quotation.
Take care. Yeah, Sunday.
We received yesterday. I do not know what is. There may be some out of context. Please.
Then, my lords, kindly see the next report, page 12.
There are 500 families of other religion. I don't want to go into it, but which are also, my lord, there, which are being removed.
Yeah. Now page 12, my lord. Page 12, your
note
lordship
of
says
the
there are 3 other reports. Now, in this entire statement, there is not a whisper about a reserved forest. And what is said is,
You are disputing it's not a this forest?
sorry, Manoj. No,
Is this
in the
not-
statement, I am saying.
No, but we are asking.
No, for a moment. I am saying, my lords, that the place where we are located is not a reserved forest. They are part of revenue villages.
That of course.
So that's a separate argument, but I am not on that. I am saying that here in the affidavit, the state has correctly come up with a stand that we are concerned about reserved forest. We want to evict people from the reserved forest. But if you coalesce it with these statements, the ground for the eviction drive appears to be something different. And that is what I want to flag, which gives rise to certain apprehensions about the nature of the adjudication which I will have before the state, especially when the top executive officer of the top executive of the state, Manoj, takes a particular stand. That's the point that I'm trying to make. Beyond that, my lords, I personally feel that so far as the stand taken in this affidavit is concerned, barring this aspect of demarcation, is eminently reasonable. But this apprehension should be allayed, my lords.
The translation of the purport of the affidavit.
Yes.
In terms of our order.
Yes.
Enabling objective and an independent inquiry.
Yeah.
I think should assume.
That is all that, my lords, we see.
apprehensions of it.
And my lords, and Because my lord, these statements are hardly in line with just these statements. I'm obliged to my lord. The statements, my lords, are hardly in line with, my lords, the constitutional, the preambular promise of fraternity.
We'll ask him.
Yes.
Mr. Solicitor.
Lord, I'll take one by one. I'll take one by one, my lords. So far as his concern about the demarcation.
One word. Tell us.
I always get to say, Lord, one word. Lord.
No, no,
It's
don't.
always very difficult after Mr.
But you never
Abadi, my lord.
Keep it up.
Unabashedly, my lord, I'm a fan of his submissions, my lord.
Yes, yes.
Unabashedly.
My lords, in fact, my learned friend is being very modest.
My lord, I somehow, my lord, come into the same division, my lord, as Mr. Goswami's client, that is Lutamai, my lord. So Lutamai, my lord, Mr. Goswami's, my lord, petitioners, my lord, they went to the High Court, my lord, they got some sort of a relief, my lord. And
What is your apprehension?
so, my lord, I, my lord, approached this honorable court, my lord, and my lord, orders had already been passed of status quo in respect of, my lord, other, my lord, areas. Unfortunately, my lord, my area, my lord, I had indicated, my lord, 2 pages in volume 2. They were de-reserved, and I was, my lord, patta holders. I will not trouble your lordships, my lord.
From the forest.
And we were given patta holders, my lord, same area. So now, my lord, despite, my lord, your lordships being in season of my lord, the entirety of the matter and a status quo order passed in a few SLPs, my lord, they have, my lord, come down, my lord, and dislocated about 1,200 families. So today, my lord, there are children, women, etc., whose houses, my lord, I have given the photographs, are, my lord, in the biting winter, my lord, they are there without a roof on their head, my lord. If there was a selection committee, I'm so sorry, 1 minute. If there was a selection committee, my lord, and a joint verification order, Lord, they should have at least come and said that, look, we'll give you a reasonable time. You come up here, show your status. We showed everything. Despite that, my lord, and despite an order in the same district, they came and, my lord, demolished. This is, my lord, unfortunate in a welfare state, my lord. And we have been there for the last 70 years.
Except this last argument, which is, my lord, more my lord, hyperbole.
Before you,
So there's no hyperbole.
these batch of matters, we will pass orders. There is one matter which has to be bifurcated. We don't have
Miss
Jaising is appearing
yes,
in
my lord, that is, my lord, for
that matter. If you give us the number, we will say that will be posted along with the other batch of matters.
yes.
Okay.
So, my lord, we are all in for joint verification today, although, my lord, we are living without
We will
it.
spend with that.
I beg
Tell
your
us
pardon.
those three.
My lord, I beg your pardon. I'm appearing in 60.1 in the petition before you today. My lord, actually, although, my lord, the arguments might be overlapping, yet the relief is different. Let me make it very clear. I am not asking for the relief that they're asking for, though the arguments relating to the nature of land may be the same. So for a moment, let me disconnect from these arguments and tell you, my lord, what my case is.
But
My lord,
in your case, we will take it up along with another batch.
along with, my lord,
Along with the other matters which we will list, and then we will hear you along with that batch of matter.
this very batch, my lord.
No, today we are concerned about the ongoing verification and then the movement on the
Yes,
basis
my
of
lord.
this affidavit.
Lord,
we
may I
will
just
dispose it out.
yes,
And
Lord,
your
may I just
case
say-
relating to that what you indicated to us, that will arise in other cases. We'll hear you in that.
No, my lord, the difference is this. The difference between the two cases I'm making very clear. Everything else is the same. However, the difference is we are already evicted. They have not yet been evicted. They have a stay order in their favor. Therefore, today, my lord, the relief I'm claiming before you is not that I should not be evicted. That is, I'm not asking for that.
We get it.
Yes. So, my lord, there are two issues as far as I'm concerned. One is the physical location of where we are is the same as theirs. But, my lord, my point is a slightly different point, which I will convey to you. I am located, rather was, now I've been evicted. We were evicted from an area which is disputed area between the state of Nagaland and Assam.
You said last time.
Yes, my lord. And in relation to that dispute, there is a original suit under Article 131 pending in this honorable court. This court has made efforts to settle it through mediators. It has not been settled. Therefore, it has been fixed for recording evidence. So, my lord, the area where I was residing is claimed by the state of Nagaland. and it's disputed by the state of Assam and saying, no, it belongs to us. So we have got caught between this dispute. That is one issue.
Where is that matter? Before which court is that?
My lord, it's an original suit under Article 131.
I have an answer. I don't wish to. I cannot. I should not.
I'm sure my learned friend has an answer.
No, but
But-
that's not to be, not for us, for the present.
There is
Really, my lord, I'm
an
told.
agreement
but-
between Nagaland government and Assam government
Suit
that the disputed forest will be taken care of.
But I did not interrupt you. Please don't interrupt me. Give me the suit number. Lord, I'll give you the suit number and I'll tell you the status.
I still
For the
remain in the
present
court order.
purposes.
So,
Original suit 2 of 1988.
yes, my lord, it is original suit number 2 of 1988.
2 of 88.
Yes, 2 of 88. And my lord, it is my express case and admitted by all sides that I am located in the disputed border area. They call it BDA. And BAD. Disputed area belt. I'm sorry, my lord, my mistake.
DAB.
Yes, BAD. And my lord, they divided that dispute area belt into belt A, belt B, belt C. Now, my lord, their case is that this belt A, belt B, belt C lie within forest areas. Obviously, my lord, the case against them and me is common. Because the notices for eviction which they gave us do say that you are in forest area. Am I clear, my lord? In an attempt to prevent this from happening any further.
Taking up
No,
these matters.
1 minute. Now, Mr. Mehta, please don't disturb me. They will decide
Please
what
be
to do.
decent. Please
Your
be
lordship may
decent.
decide what
We
to
are in the
do.
court of law, not in.
No, my lord, I'm sorry. I will not be interrupted like this. I will walk out of the courtroom if he interrupts me like this.
We are stopping him from interrupting. We are,
Yes.
We are asking.
Yes, I'm
We
ready
are
to
asking
answer
you,
any question.
We are asking you.
Yes.
Those aspects we will consider when we take up that matter. Why are you addressing us now?
No, my lord, I'm in your lordship's hands. If your lordship wants
No, not
me,
now.
so therefore I'll just conclude by saying 2 things. Number 1, my lord, there are 2 ways of looking at my problem. Either, my lord, we see whether that suit 2 of 1988 can be fast-tracked and decided. That's one way. That's one way. The other way is what I have put down in my petition, my lord. I have said very well, if you can't relocate me back into that area, I need to be rehabilitated and I need to be compensated because I've been a resident of this area at your instance.
We will note about your.
So
your
these are
concern. We will
third.
say this should be-
And third, my lord, very importantly, urgent. This is urgent. The first 2, your lordship may hear anytime. I don't have a problem, my lord. Anytime your lordship
Third is
wants to.
what? Third is what?
The third is, my lord, every one of us. And right now, there are 280 petitioners before you, 230, 224 petitioners are before you. They all have their families. Now, my lord, the third thing is we are all on the voters list. All of us on the voters list. All of us have Aadhaar cards. All of us have PAN cards. All of us have an identity issued by the state. All of us are recipient of benefits of the state. Now, my lord, the problem is they are removing us from the voters list. I have made the Election Commission also party to my petition. They're respondents. My lord, very urgently, I cannot be removed from the voters list. That is,
How is
that's my petition. It is my, no, my lord. They are removing me from the voters list on the ground that you don't have a residential address. Now, why do I not have a residential address? Because you evicted me.
But Mr. Ahmadi, this issue relating to voters list will be considered by us here.
No, this is completely different.
No, but
Not having a PAN card doesn't
Not
mean
as far as I'm concerned,
not a title
your
document.
lordship may see I have made the election commissioner party respondent to my petition. Your lordship may have a look.
How does it arise?
In my petition, it's
They
declined
said-
for eviction.
Okay,
My learned friend-
can we do one thing, madam?
Yes, my lord.
You are concerned about voters list.
Yes.
We will bifurcate it. Your matter seems to be having very, very different parameters.
2
With
issues.
respect to the borders, with respect to voters list and so on. This we will deal with separately.
I have
Just
no
keep your
problem.
powder dry. We were not rejecting your case.
Very well.
Keep your powder dry. We will ask him about this application first. Mr. Solicitor,
My lord, first
tell
of
us
all,
those other concerns. This you need not answer.
no, my lord,
And
I,
this we will
no,
post.
I'll not
Our
respond to this.
application number, you just
I
post it.
will not respond to this.
You don't need to respond to
Yes.
this.
My lord, so the first concern of Mr. Ahmadi, that there should be a demarcation. But demarcation does take place. But I'll just show it, my lord, and give it to Mr. Ahmadi also, my lord. That this is a forest area, that is the first demarcation. Your lordships may kindly see para 1. Introduction, your lordship gets, my lord. I'm not
Make
going
a
to.
statement, that's all.
No, I'm not.
What is
My lord,
the
I want to show something. See, look at the page 1.
Yes.
Lutumai Reserved Forest was notified with a so-and-so. Thereafter, the 2, objective of the joint survey. The joint survey was undertaken to demarcate the encroached areas within Lutumai Reserve Forest, identify specific blocks to be taken up for eviction, record so-and-so, and thereafter, my lord, who are the officials present, all of them sign, and thereafter, my lord, notices are issued, and the boundary coordinates, everything, my lord, at page 3, your lordships would find, my lord, is given. Now, my lord, page 3, internal page 3, my lord, it's not paginated, but your lordships would find boundary coordinates of Lutumai Reserved Forest. And these are all signed documents signed by, my lord, from Revenue Department as well as, my lord, the Forest Department with map, etc. And similar exercise, my lord, this is a one model demarcation, similar exercise for all reserved forest areas. My lord, so far as...
1 minute. Then there's some other concerns you must answer.
Yes. My lord, now, my lord, look at the system. How we...
This is struck down by the High Court. That is what you have not been properly instructed. This is what was challenged before the High Court, and the High Court has struck down this. This is the report. This is the report which they finally accepted was unilateral.
No, this is done after the High Court order, sir. I'm without any personal reason or emotion, I am arguing as a proposition of law. I have nothing to do with anyone. Lord,
Check up Goswami, and you tell us, don't interrupt him, check up.
Second, whenever, Lord, how do we take care of fairness? Sir, if you don't mind. Fairness, my lord, and impartiality. Lord, the notice is issued, the committee is constituted. Committee consists of, my lord, 2 departments, forest as well as revenue. The main aspect, my lord, based upon which your lordships would judge impartiality, the procedure in accordance with law, and objectivity is from the fact that I have made a statement that a speaking order is passed qua each occupant. And that speaking order is amenable to judicial review by the highest constitutional court of the state. My lord, no officer would take the risk of, my lord, passing an order which reflects false facts. Therefore, my lord, my affidavit is, my lord, all encompassing, ensuring objectivity, that it is a committee of 2. If right now the drive is only qua forest, if it is
your state.
Yes, if it is a revenue department, it will be sent to revenue department. But in Gaon Panchayat area also, but I don't wish to go into it because in fact specific situation, there will be a separate order, qua each encroachment, even in Gaon Panchayat area. But that would be dealt with by the authorities concerned. And all these orders, my lord, are amenable to judicial review. My lord, what is placed before your lordships is, my lord, excerpts, my lord, which are attributed to someone. My lord, based upon that, your lordships may not...
That assurance that you have given.
Yes, my lord.
And that statement that you have made is of importance. We will record that and we will also pass orders.
Please, your lordship.
On the basis of that.
Yes, my lord. But, my lord, your lordships may, my lord, leave it to the committee.
You will not say anything. We don't want to complicate it by putting things in those so
It has to be fact specific. It has to be fact specific.
You unnecessarily argued these aspects. You keep it aside so that it's open-ended for you.
Very well. Just one aspect, just to correct.
There is one aspect I need to point out.
Just to correct.
Dispose of the matter. Now,
no, we are not going to keep this here pending.
No, because in the first matter, item 60, the High Court had dismissed the appeal. on the ground that we have to be
Dispose of
evicted.
in terms of that. This is not a substantive matter. This is a case
No,
which is
in the sense that my rights then have to be preserved because the High Court has accepted the statement, the best statement of para 16, the High Court records my argument that it's a Gaon Panchayat
Whatever,
notified.
we are not going to interfere in that. That whatever is the rights that have accrued in your favor, we are not going to
No,
disturb
no, I'm
them.
not on rights. The High Court has dismissed my appeal, saying that the single judge has said that you should be evicted, so you should be evicted. Your lordships are given a status quo on that. Therefore, I'm saying that
That too will,
I have to be
that one will.
protected. I have to be
The High Court has said
Till
that
the
the
decision
procedure
is
is followed. My lord, I'm sorry, High Court has said procedure is followed.
No.
A reason speaking order is passed.
Till the logical conclusion takes place by virtue of the
Yes.
affidavit and inquiry and show cause notice and all that, eventually till an order is passed, they might find you to be a legitimate occupant.
Yes.
These orders
They
should be.
might find you to be a
No,
legitimate
if your
occupant.
lordships are disposing
You are
of the
not going to
matter,
dispose.
I'm only saying that these orders would need to be substituted because if there's a dismissal,
May I
that
just-
would operate as res judicata.
This-
My lord, only one more
Do
last
not
thing.
take note of this.
My lord, one last
What
thing.
you are saying is right.
This is precisely the document that was challenged.
No, my lord, there is no, it's not, my lord. But anyway, my lord, another aspect, my lord. I don't wish to answer, my lord, that Nagaland issue.
Taking note of it, so therefore don't worry.
Not Nagaland.
No, I'm not on.
This is
Sir,
one.
there are other matters as well on your side.
This is
In
precisely.
I don't.
Orders will be passed.
Yes.
Only one thing.
Problem referring to
No,
women.
please.
Right, I'm
Now,
edgewise
now
to
calm
you.
down, everybody.
I'm
Then
edgewise
we
to
will
lot
pass
of
order.
edgeways.
Just one and
Heard learned counsel for the petitioners and the
Anyway.
respondents.
Yeah.
And
Yes.
also heard the learned solicitor general,
Learn
behalf of
how
the
to
state
deal
of-
with women lawyers.
state of. Okay,
Anyway,
ladies
my
and
lord,
gentlemen,
I would
on
not, my
behalf-
lord,
on behalf-
demean myself by responding.
on behalf-
Every time, my lord, I can't have that victim card being played.
And he
What
calls me
happened?
edgeways in this court.
Edgeways.
You're present.
What did you say?
Edgeways. Did any one of you hear that? Mr. Josefa, I'll rely on your word. Did I say a word?
We haven't heard him say.
No,
anything.
let Mr. C.U. Singh is here. Let Mr. Josefa say. Mr. Goswami may say. What is this, my lord? Every time playing a victim card because I'm a woman? I didn't say anything. I didn't say anything, my lord.
please.
He's the one.
I didn't say anything to her.
We haven't.
I always
heard-
keep my lord, a
we haven't
respectable
heard you
distance
saying
to
anything
maintain
like
my
that.
respect.
Spot.
I don't think other colleagues also have not heard. Now leave it at that.
may I only
Heard
point out,
learned counsel
just,
for the
No, Mr.
petitioners.
Josefa, you may clarify if you have heard.
no, I didn't hear.
So far,
Lord,
as
Mr. Josefa has not heard, nor
we haven't heard.
yes, then no, I didn't say anything to her, my
We
lord.
haven't
This is
heard.
Mine
this
is-
has become, my lord, quite usual.
I heard somewhere else.
Oh, it's
But-
usual, is it?
We heard learned counsel for the petitioners and respondents.
I just want to make one point before your lordship.
Heard the matter. We shall be passing orders in all these matters.
Your
Which
lord,
we will not take into public.
Lord,
Yes.
Nagaland,
Yes,
etc. will file, my lord.
That only we will just bifurcate that matter.
Yes,
Give us
Lord,
the number.
I have an answer, but I'll not give it right.
We are not even
Yes.
dealing with it. Give us the number.
May I take it?
Now I think you can leave this now.
No, fine. May I take it now? Matters are DTAC.
Yes.
Very good.
just one aspect that I wish to point out is that insofar as demarcation is
Sorry,
concerned,
acrimony for.
just one.
My lord,
I'll just
unless,
First day.
my lord, I had
we
to,
did
I'll
see
just
the
take
subsequent
30
order.
seconds.
Lord, I had to
Should
call
also
my
be there.
learned friends as my witnesses that I did not utter a word. And
No.
fortunately, my lord, Mr. Singh and Mr. Ahmadi and Mr. Goswami said, yes, there is nothing he said.
Even we haven't
We-
heard Mr. Solicitor. Doesn't matter.
What
Leave
are
it
we,
there.
Lord?
Just one aspect, no? Just
What is it?
page 62, your lordship may just talk in 60.2. This so-called demarcation, even pursuant to this order, has not yet taken
We
place.
will not say.
I'm
But
only
we
pointing
understand.
out.
Don't amplify it.
So-
It will not.
So let's not put the cart before the horse.
We are not doing it.
You can't ask someone to show cause first without a demarcation.
Who's going to give that number of that other connected matter?
60.1, my lord, I am giving.
2.1 उसके साथ लगा देंगे.
Any
And-
other matter
We'll
we
get
can
it.
appeal.
Well, we wish to thank your lordship for a
Absolutely,
very patient
absolutely.
hearing.
My lord, thank you.
This is what happens every day.
Grateful, my lord, for being very patient.
Including patient with me, my lord. Thank you very much. My lord.
That's not an easy task.
Your lordship will indicate the date.
Yes. No date. That you'll have to mention to the chief. That's not before us. We'll post it along with that.
Lordship
court
will kindly
master password,
indicate the date. I just have to address you on the
Password,
question.
sir? बुला लो, बुला लो.
Great.
Right.
Grateful.
64. Yes.
Chanda,
Flights to come down.
let's do forget.
God save.
Lordship, may I request a short passover as my main counsel is.
Excuse me, you're standing on my ground. Thank you.
Sir, tomorrow is the election and
कौन सा वाला? Item?
May it please, Your Lordships. Let's urge only one point, my lords. Power of attorney coupled with interest, section 202. No, 64, 64 bula. Sir.
Sir, you can't wait till next week. We'll hear you. Tell us. Yes.
Sir, Lordship, I have been elected uncontested president on 25th of September of 25, and I took on.
May it please, Your Lordships. That's power of attorney coupled with interest. Section 202 makes it very clear. Illustration B. Let's obviously, let's the transfer. Because of the prohibition, they had to be resumed. They had to be transferred back.
You are for whom?
For the caveats.
Caveat. Okay, this matter.
So, let's. The only finding of the High Court is
Prohibition
that
of
the
sale was there.
prohibition. Because of that prohibition, it had to be conveyed back. Now, let's rightfully, I had paid consideration. I had purchased the property. Because of that prohibition, it had to be conveyed back. Then, let's they execute powers of attorney. Now, powers of attorney, the power of attorney is coupled with interest. 1996. Now, the only finding.
This is called prayashchit. For the initial sins of buying it during the prohibited period, it has
So
come
now,
back to you.
now, my lords, legally, I quite understand. Now, consideration has flown. I am in possession even till today. Now, because of the power of attorney, the revenue records are mutated. Now, the only finding of the High Court is that the power of attorney goes with the death of the principal. That is
First appellate court's finding.
that is the only.
Held.
No, that is the only question decided. Now, that, my lords, section 202 of the Indian Contract Act, illustration B, is very clear that when the agent has an interest in the property, then the power of attorney does not cease to exist despite the death of the principal. Your lordships have said so in any number of judgments. Now, all that has not been considered. Now, my lords,
Dismissed. Next.
my lords, I have been in possession. My learned friend is here. Right from 1983, I have paid consideration.
Time and you will not vacate, and he will file a contempt.
It has been disbelieved. The plea of his possession has been disbelieved.
I was only
and the
suggesting,
paper
my lord,
possession.
73 others.
Yes, paper possession was in pursuance of the GPA, not in pursuance of transfer of possession.
Even as on date, my lords, the revenue records are in my favor. Very well, my lords. Very well.
Next.
Would your lordships give me some time to vacate, my learned friend?
I don't know.
Very well.
Yes, I appear for the petitioner, my lord. In this case, my lord, what has happened is that yes, my lord, there is an application for an interim relief.
What is to be done in 41?
Yes, my lord, I'll tell you, lordship. My lord, what has happened
Let
is
somebody from government come. Just examine that matter.
My lord, learned AG is logged in.
Yes. Who is appearing? Mr. Natraj.
yes, please.
What is to be done in this?
Now the application is against the state government. Now we have already accepted the report of the expert committee.
this matter is. We have no idea what is to be done in this. What is this for? Just give an idea about what is to be done. You want us to put it up on some other day or what?
I think NMD we may have to hear it. There was an expert committee constituted for the purpose of pursuing this one, the fishing. For that expert committee is constituted, it has submitted its report, and that report has been accepted by the central government. We have forwarded it to the respective state governments to